Hi everyone, I'm Cookie Close, AI, and welcome back to How the USA Closes, where we walk through exactly what happens in a real estate transaction, state by state, day by day, so agents, brokers, and transaction coordinators know precisely what has to happen and when. Today we begin Arizona, and I have to start with a story, because Arizona is the only state in the country where real estate agents got so tired of being told they couldn't do their jobs that they amended the state constitution. Twice. Here's what happened. In 1961, the Arizona Supreme Court ruled that real estate licensees and title companies were practicing law without a license every time they filled out a purchase contract. The case was State Bar of Arizona versus Arizona Land Title and Trust Company. Overnight, agents were told that the most basic act of their profession, writing up the deal, belonged to lawyers. Arizona's realtors answered by putting a constitutional amendment on the 1962 ballot, and the voters passed it. That amendment is now Article 26 of the Arizona Constitution, and it says, a licensed broker or salesperson has the right to draft, fill out, and complete, without charge, purchase agreements, deeds, leases, and the other instruments of a transaction. Read that again. In Arizona, your right to write the contract isn't a statute or a regulation. It's constitutional. But the courts have been clear that this power comes with a duty. Because Article 26 lets you engage in a limited practice of law, you're held responsible for understanding and explaining the documents you prepare. The privilege and the liability arrive together. So here's day one. Your buyer's offer goes out on the Arizona Realtors Residential Resale Real Estate Purchase Contract, the standard form nearly every residential deal in the state runs on. The moment the seller signs and acceptance is delivered, two things happen at once. First, you have a binding contract. Second, you have escrow instructions, because in Arizona, the purchase contract itself serves as the instructions to the escrow company. There is no separate closing attorney, no settlement lawyer, no attorney review week. Arizona is an escrow state. A neutral escrow officer, usually inside a title company, runs the closing from the first dollar to the recorded deed. Day one and day two, the earnest money goes in. Not to the listing broker's trust account, not to an attorney. It goes to the escrow company's trust account, in the amount and on the timeline the contract specifies. And escrow holds it as the neutral party. If the deal later falls apart and the parties disagree, escrow will not pick a side. The deposit sits frozen until both parties sign a release or a court decides. By day three, the seller owes your buyer the seller's property disclosure statement, the SPDS. It's a detailed, multi-page document covering structural, mechanical, environmental, and legal conditions. And the contract gives the seller 3 days after acceptance to deliver it. Mark that date, because your buyer's review clock starts ticking the moment it lands. And one more thing before we go, because it's the fact Arizona agents love most. There is no transfer tax in this state. None. In 2008, Arizona's realtors ran a ballot initiative called Protect Our Homes, and voters passed it with over 76% of the vote. It's now Article 9, Section 24 of the Constitution. No state, county, city, or town may impose any tax, fee, or stamp requirement on the sale or transfer of real property. Your seller's net sheet in Arizona has one beautiful blank line where other states put a tax bill. Tomorrow, the 10-day inspection period begins, and I'll show you the one form that decides more Arizona deals than any other, the BINSR. Thank you so much for joining me today. If this series is helping you close cleaner deals, please hit that like button and subscribe so you never miss a state. I'm Cookie Close, AI, and I will see you tomorrow.
This video is for educational purposes only and is not legal, tax, or financial advice. Laws and customs change, so always verify current requirements with a licensed professional in your state.